To the Cannabis Educational Forum here at the Bedford Legion. Thank you to the Bedford Legion for the fabulous space here and getting everything ready for us. It's greatly appreciated. My name is John Percy. Most of you know me. Hi. I'm going to be the moderator here this afternoon. And in the first round here, second round will be Skyped from Vancouver. First round here, we have live on our stage. On the very right here, we have Marcel Dignan, and he's the Communications Officer for the Medicinal Cannabis Patients Alliance of Canada, and an IT professional. And we all know Marcel, I'm sure, and look forward to his comments here on the legal ramifications that are about to befall us on April the 1st of this year. In the middle here we have Patrick Atherton. Patrick's been practicing in the area of criminal law and has represented clients facing a full range of criminal matters. Patrick has met with success for his clients in provincial court, Supreme Court, and the Nova Scotia Court of Appeal, and has been called to the bar since 1997. He has a wide range of experience with criminal law, and that is something that we're going to have to know a heck of a lot more about. We welcome Patrick here and his ideas. Directly to my right, we have Dan Wallace, and Dan, I'm proud to say, was co-counsel for the Veterans System class action suit that was finally, after 6 or 7 years, 7 years, was won in the Federal Court of Canada, and that was a class action suit brought by over 7,500 veterans to have their disability clawbacks stopped. And Patrick was co-counsel, and certainly on behalf of all the veterans of Canada, I would like to thank Dan for his contribution to that. The Dennis Manouche case has resulted in one of the largest financial recoveries in Canadian legal history, and all we need now is for the government to actually pay out. They seem to be a little slower on that than they do on defending themselves against prosecution. Dan has appeared on The National, The World at 6, and various other media outlets discussing the Manouche class action and other issues facing disabled veterans. Dan is going to speak on the ramifications of putting a class action together, which has already been started across Canada, and with regards to the regulatory changes on April 1st, and we certainly look forward to his insights into how that's going to work. What I'd like to do to start us off is that if each of the three can give a brief opening statement, and then we will start speaking to their own particular areas of expertise. Okay? And this microphone here is going to be for questions from the floor. If you are uncomfortable with being on camera, then I will take the microphone down to you to a place that is off camera. If you are comfortable being on camera, it will be right here at this podium. Okay?
Where is the camera?
Yeah, the cameras are focused directly on the front table here, so there's nothing in the, showing the audience at all. I know some of us are a little nervous, and it's understandable. So if you are nervous with being on camera, just indicate to me, and the microphone will be taken off camera too. Okay, so let's get started, and let's start with Marcel on the right. Brief opening statement, sir.
I've never briefed, so I'd like to thank everybody for coming out. Obviously, everybody in here has some worries. Hopefully we can address some of those worries here today. For those who don't know me, I'm the Communications Officer for the Medicinal Cannabis Patients Alliance of Canada, which is really the only federally registered not-for-profit society fighting for patients to be able to keep their rights to grow. We've been incorporated not-for-profit for just over a year, actually almost 2 years, or coming up to 2 years now. We're coming up to the deadline. We've been saying this and fighting this for the last 2+ years because we knew this was coming. So we're coming up to the deadline. And with the deadline, of course, comes a lot of brainstorming, so maybe a little later we'll give you an idea of some of the things that we're planning for, we'll call it civil obedience, all right? In a way that everybody can actually contribute to stop this basically travesty from happening. For anybody that's not aware, the new program that's coming into effect takes the rights away from the patients to have their own gardens or a designated person grow for them. For people growing indoors, this of course is going to be a substantial increase, but for the people like me that grow outdoors, it's going to be detrimental. And more patients realize the benefits of growing outdoors because the sun is free. Cost to grow outdoors, naturally organic, is less than 5 cents a gram. The cost to buy from the new program is going to be in excess of $12 a gram after you look at your taxes and shipping. So that's over a 700 times increase of what it would cost us to grow our own. Plus, ours doesn't get treated with radiation. So all of the new product that's being shipped to you is not only being grown in chemicals, it's going to be treated with radiation, then mailed to one of those super mailboxes for you to hopefully get out and still find it there. And then I'll pass the microphone on to Mr. Pat.
Thank you for the kind introduction. I guess my comments will be directed to how it is viewed in law. Marijuana is simply one drug among many. It is regulated under the what's called the Controlled Drugs and Substances Act for historical reasons. That act is administered directly by the federal government as opposed to other criminal matters or criminal code matters which would be administered by the province. It's treated under Schedule 2 of the Act. It remains prima facie illegal in Canada to possess, use, or consume marijuana unless you have a medical prescription for a medical condition. One of the concerns that's driving the over and above their policy or their moral belief that marijuana is bad for you is that some people have abused the MMRs and used grow licenses to produce marijuana for sale illegally, although it is by far and away the most common so-called street drug in Canada. And in many respects, because of the philosophical opposition of the federal government to marijuana, and it was only very grudgingly they ever allowed the MMRs in the first place, they have significantly tightened up how that is going to be dispensed to patients. I think more broadly speaking, any kind of a challenge to suggest that the government does not have the right to regulate the production and sale of a controlled substance is destined to fail. The kind of challenge that will work and has worked in the past and in fact led to the individual licenses is wherein a successful party, an accused person in the criminal law context, can demonstrate that the government regulations and control of the production and eventual transmission to the patient is so onerous or expensive so as to effectively deny you the benefit of that medical prescription will likely succeed. However, in so making that sort of a challenge, you need to lay out a very careful evidentiary basis for that kind of a case. So in broad strokes, of course, in my view, will recognize the right of the government to regulate it. What they will do is ensure that the method is one that is fair to patients who prescribe marijuana, yet also consistent with the right of the government or the duty of the government to regulate controlled substances. And I think if you look at the challenge that's in MUMM's the word there, I think that's in very short form what I've just told you in long form, that legal expert Alan Young feels the success of Sesniak's challenge depends on, among other things, the shape the new program takes as it is rolled out. I'll answer specific questions later. Over to Dan.
Thanks for the introduction. Thanks for the introduction, John. My name is Dan Wallace, and I'm a lawyer at McGinnis Cooper here in Halifax. And I specialize in class action litigation. Class action litigation is, it recognizes that it's very hard to, lawsuits are very hard, they're very difficult, they're long, and they can be very expensive, particularly when you're suing the government of Canada. As John said in his introduction, the last 7 years of my life have been spent suing the government of Canada on behalf of disabled veterans, and we were successful. We had to go up to the Supreme Court of Canada once, and then we had to go to the federal court again. So we probably had about 24 hearings in front of the court over the last 7 years. But what a class action does is, instead of suing on behalf of one person, it aggregates everyone's claim, and you can do it on behalf of dozens or hundreds or thousands of people. And in this case, my next case is with my colleagues is on behalf of a lot of you folks, and that's for the approximately 40,000 medical marijuana users whose privacy we say was breached in November 2013 when they and you most likely received a letter from the Health Canada which clearly stated on the envelope that it was from the medical marijuana program. And since we started this claim, we started it in November 2013, we've heard from thousands of people, and everyone's story is unique, but there's a lot of themes, and you know, sometimes the letter might have been delivered to the wrong house, sometimes the letter might have been read by someone in the member's house who didn't know that their father or son was using medical marijuana. So we've heard from a lot of you, and we still invite you to keep on contacting us and tell us your story about how this privacy breach has affected you. So plainly, just in summary, the case is that the government of Canada, through Health Canada, violated your privacy by sending this letter and indicating that you were a member of the medical marijuana program, and that could have caused you difficulty in your work, in your community. It raises security issues, which is acknowledged by the letter that was in the envelope itself, and that's part of the tragic irony of this. Is they said, you know, this program is opening you up to it's open to abuse, and it's causes a threat of home invasion. So for the safety and protection of Canadians, we are ending the program as you know it, and as it has generally been working for you. And then they put that in an envelope that had your name, your address, and said the medical marijuana program on it. So you know, clearly there's some employment, health privacy issues, as well as personal security and home security issues. And so we've started this action. We've started on behalf of a gentleman here in Nova Scotia. He wants to use a pseudonym because obviously if you're suing because your privacy was breached, you don't want to proceed with your actual name and your address to be known to the public. It's kind of the government is opposing this motion, so that's the next step. So on February 20th, we're going to be in federal court here in Halifax on behalf of John Doe to continue proceeding as John Doe to represent the 40,000 members. And I should mention that we are combined with two other law firms, one in Vancouver and one in Ontario, and they are terrific counsel, and they're some of the best lawyers in Canada in class actions. And here in Halifax, David Fraser is one of the lead lawyers here, and you might often hear him on the radio. He's a privacy law expert. And so we have got John Doe here in Halifax, and then there's a lady by the pseudonym of Susie Jones, and she resides in Ottawa. So on behalf of John Doe and Susie Jones, the next step is to have them be able to proceed in using those names as opposed to their actual names, and to be able to erase and redact any personal information that they may have. So that's going to be heard on February 20th here in Halifax, and we will advise how that goes. If we have to use someone's name, then we will do that. I know there's people that are willing to put their name forward on behalf of everybody, but hopefully that won't be necessary, and we're going to ask the court to say that's not going to be necessary. It certainly is a catch-22 in order to fight for your privacy, you have to reveal your name. That's just doesn't seem right, and that's what we're going to be arguing. So the next step after that is going to be to certify the case. And to certify the case, it's basically a procedural, technical issue, but it's very, very important. And that's when a case is certified, it means you're not fighting on behalf of one person or two people, John Doe and Susie Jones. You're fighting in their names on behalf of everybody who meets the definition. And the definition in this case is that you received a letter with your name on it and with the medical marijuana program written on that envelope. So if we get certified, the court's going to say, for the efficiency of justice, for access to justice, we think it's in everyone's interest that this case is going to bind all 40,000 people. For better or worse, if they win or lose, the result's going to bind everybody on the common issues, because everyone here is the common issue of the rights being breached. And if we're successful there, that would be great news, and that would certainly put a lot of pressure on the government of Canada, because now instead of dealing with 2 people, they're dealing with 40,000 people. It certainly puts a lot of political pressure on them. And then the next step after that would be to actually hear the case. So I know one of the questions is timelines. Unfortunately, these things tend to move slow. Just the way the court process is. We're pushing it as quickly as we can. February 20th is going to be the date for a confidentiality order to be able to use the pseudonyms to proceed. And then in the spring, late spring, early summer, we're going to have the certification motion if all goes according to plan. We've heard from a lot of folks. We've have a paralegal who's devoted to just corresponding with class members who call in or email us at McGinnis Cooper. The firms have put together a website. It's called marijuanaclassaction.com. And marijuana, in this case, is spelled with a J. I never knew anyone ever spelled with an H until I got involved in this. So marijuanaclassaction.com is the website, and that's just for you to register. It's a secure site. Your privacy will be kept. We take your privacy very important, so it's going to be kept. No one's ever going to know that you signed up on this website except for us. And it gives you an opportunity to provide your contact information, but also to explain to us what this privacy breach has meant to you, whether it's cost you any money, whether maybe it's cost you your job, or if there's any other circumstances that you think you'd like us to know about. So it gives a way to be able to hear from the class members. And I guess that's all for my introduction, but if you have any questions, I'd be happy to answer them for you.
Thank you, Dan and Pat and Marcel. I know there are questions out there, and we're going to turn the floor over to questions. I would ask that the questions be succinct, that there is a question there, a 5-minute preamble to your question. It doesn't really serve the time that we have allotted here. If you have a question, ask the question. I'm going to start, actually. And one of the reasons for the changes that are coming on April 1st is there's this constant talk of abuse of licenses and how we're cutting down on people who have fraudulently obtained licenses and are abusing the system and are selling these drugs on the street. In everything that I have seen and read, the percentage of abuse is somewhere below 5%. With any human-created system, whether it's governmental regulations or otherwise, you're going to get anywhere from probably 6 to 10% of people abusing that system for their own personal gain. Whether it's welfare or whether it's the Senate or corporate malfeasance, you're going to get anything that you put together a set of regulations that people must adhere to, you're going to have to write in. And governments do this. They write in a certain abuse percentage that they expect to see. And that's generally, in government, falls around the 6 to 8% range. They expect that level of abuse. So if we're coming in at under 5%, it just seems rather disingenuous to me that they're using that as a reason to make a lot of these changes. And I'm wondering if anyone here, Pat especially, can speak to that at all. How governments justify making these changes based on information that to most people that information is publicly available just doesn't hold water.
Politicians are high on drugs.
To be frank about it, I tend to deal with the consequences of arrests as opposed to policy considerations that go into making decisions. I think from a philosophical standpoint, the present government view marijuana as a so-called gateway drug, i.e. the idea is that if you use marijuana, it will lead to the consumption of other rather more pernicious substances. The most popular around here is cocaine. I think, quite frankly, the actual evidence of that is, to say the least, thin or non-existent. Certainly, as drugs go, it's not very often you hear about a domestic dispute between two partners after they've spent the night toking. It is very often that you hear of a domestic dispute between two partners after they have spent their night drinking. And certainly, as an underlying factor in many criminal offenses, one would, at a very sort of practical level, I would say it's 80% alcohol compared to less than 2 or 3% where marijuana is involved. But that really is a policy question. The federal government have chosen for their own reasons to change the way this drug will be dispensed to those people who medically need it. They have also changed, you should be aware of that, that production, which is a separate offense, has now become the subject of mandatory minimum penalties. Mandatory minimum penalties mean that what was the common outcome for a small-time grow-op since I've been practicing law, or since the initial sentence orders came into being, which is about 1997. Because there are mandatory minimum penalties, people who produce marijuana are likely now to wind up going to jail. That's not necessarily so, and they classify it as follows. The subject matter of an offense is cannabis marijuana is guilty of an indictable offense and liable to imprisonment for a term of not more than 14 years and to a minimum punishment of imprisonment for a term of 6 months if the number of plants produced is less than 201 and more than 5, and the production is for the purposes of trafficking. And then penalties go up as the number of plants increase. I want to say a little word about trafficking. People, the common sort of street idea of what trafficking is that it means that you sell drugs to somebody. In fact, the legal definition of trafficking is much wider. So, if two of you each have 5 plants in a basement somewhere, and person A is growing for person B because they don't have the space or the aptitude or the green thumb, whether it's indoors or outdoors, that is, because you're growing it for somebody else, that is production for the purposes of trafficking. The other aspect that people should consider is that there are very, very onerous forfeiture provisions in the CDSA, the Controlled Drugs and Substances Act, for what are called offense-related property. that's why you'll find that people who are doing this for commercial grows are almost inevitably use rented property. And the reason is because if it's a fence-related property, it is subject to forfeiture. So you could own a home that you've spent 20 years and you grow your few plants in the basement. You know, theoretically, the government will go after your house. If you're growing for your friend who's unable to do it by virtue of their medical condition or doesn't have a green thumb, it's for the purposes of trafficking, they can take your car when you drove the weed over there. You should be aware of that. All property that is related to the production of involved in the production of the substance, whether it's marijuana, the other sort of big ones you don't see around here, sort of meth labs, they're more up in the west than they are down here. But all of that stuff is subject to forfeiture. So for those of you that think you're going to fly under the radar and just keep your little grow up in the house, you might well fly under the radar. But if you get caught and they try to bring the full rigor of the law into play, you can conceivably forfeit your house. So you might want to think about that. It's not just, you know, if you stay under the 5 plant limit, there are no mandatory minimums. If you get nailed the second time, you can almost guarantee it will be very difficult to persuade a judge not to put you in jail. I know that it is not a popular policy among the bar, and even among some prosecutors that I know, but they aren't in the business of making the law, they're in the business of enforcing it. I guess I'll shut up at this point on that point.
With regard to the courts and more than 5 plants, and after this I'm just going to turn it over. With regard to 5 plants, how much leeway is there going to be? Because as anyone in this room knows, if you grow anything from seed, from whether it's lettuce or whether it's cannabis or whether it's broccoli, you don't plant 5 seeds and expect to get 5 plants. You plant 100 seeds and take your best 5 and allow them to grow. So if you are caught with a tray of 50 seedlings that are 6 inches high, these are each one considered a plant, even though you are going to cull that down. In the eyes of the law, it appears that you are trafficking because you have 50 plants. Is there going to be any consideration given for that under the mandatory minimums that, or is everyone basically going to be drug trafficker here?
My view would be that a plant is a plant. What you intend to do with it in the future would be of little relevance to the judge that you're in front of that day. I mean, I understand the botanical logic behind what you're saying, but you know they tend to be fairly literal-minded about these things, and they're going to say, "Well, Mr. Atherton, there's 50 little plants there, and whether they're big or they're small, they're still plants." And it would be very difficult to argue otherwise. To argue that at a future time, the stated intention of your client was to cull it down to 5. I think they're going to go in there and they're going to count up the plants and say that's how many there are. The bigger issue would be, I think, proving that it was, and the production is for the purposes of trafficking. If you had been, for example, habitually growing for yourself over the last number of years, and your evidence was, well, I started off with 25 or 50 plants, and then I cull it down to whatever, and then I only consume it myself, then I think the court would have some difficulty in drawing the conclusion that they would have to prove beyond a reasonable doubt that you had those extra plants for the purpose of trafficking. And that certainly in medical cases, if you question the counsel, what purpose do you have the drug for? Typically, the other ancillary evidence of why you have the drug is typically led and discovered on searches. You know, for example, if you got dime bags or packaging like tinfoil for crack, do you have a large quantity of cash? Do you have scales? Do you have score sheets? Do you have texts? That kind of stuff. So it's not simply that you can't just say the guy had 50 plants, it was for trafficking. There would have to be other ancillary evidence to support that proposition. But I remind you that if you're growing for somebody else, it's not in the classic sense trafficking, i.e. for profit and to sell to other individuals, you're helping out a friend. But that would be caught by the definition of trafficking. That's the problem you have.
When I first got my license, I contacted Health Canada to give me any information on how to grow this and how to look after it. And they told me that no information was available, that it's up to yourself to go to the internet and libraries and figure out how to do this yourself. But the one thing they told me is that, like, I had a license for 6 plants, and they told me that one plant constitutes 3 seeds in one pot. So if all 3 of those seeds germinate, then you've got 18 plants, and they're telling you you only have 6 plants.
Did you get that in writing?
No, I got that over the phone from Health Canada.
I would love to have that in writing.
Me too now, but that was like 8 years ago.
The problem with that is when you call Health Canada, you're calling a call center. We're call center employees that read from scripts. They'll take your information. If you have questions they can't answer, then they'll have a manager call you back. Well, the manager is still just another level up in that call center.
So I can't depend on the information that I get on the phone?
Unless you can get it in writing and it's signed by Mr. Perot, and then it's legit. But what you get for information over the phone, no.
So
unless,
that information
unless you're
over
smart
the
enough
phone,
to record all your phone calls.
so that information over the phone is leading you down the garden path.
We've had many questions where we've had many individuals ask them the same question and come back with completely different answers. Another one was in regards to greenhouses.
Yeah. In regards to what?
Whether a greenhouse is considered indoor or outdoor.
Like, I couldn't get information about greenhouse.
The answer that I got back was if the greenhouse is in such a way that you cannot see through the side walls from street level to see what's growing, it's considered outdoor. Or no, sorry, a greenhouse is considered outdoor regardless. But to have a greenhouse, you can't be able to see through the wall from street level to see what's actually growing in it. So my question was, since I can grow outdoors, I can put, or no, let me go back. If you can see through the walls of your greenhouse, it's considered outdoor, all right? Which means that you've just got plastic walls or glass walls. If you enclose the sides, whether you have a top on it or not, it's considered indoor.
So a dirt floor with no roof is still indoors?
Still indoor as long as you can't see it. If it's got solid walls and you can't see through it, and it's not of a material that could easily be cut or opened up, that's considered indoor. And the difference being, my outdoor license is 74 plants. My indoor license is 146.
Build a house with a tree in the middle. There's all kinds of lights right there in the sun.
All right, but that's basically what their answers were. But other people have come back with answers from Health Canada that said that greenhouses are all outdoors. It doesn't matter. It's just all considered outdoors, whether you can see through them or not. So it's a matter of who do you believe. They wouldn't give it to me in writing.
So what do you do then?
74 plants. Instead of 146 treated as an outdoor. Because, I mean, seriously, if you're going to grow outdoors, you're going to grow some big plants, all right? Especially in an enclosed space like that. You can manipulate your grow to the extreme and have bumper crop that'll last you for 2 years. Right? So you don't really have to go with 146 plants and then end up being over your allowable storage limit. right? So even really good growers, you want to make sure you don't go above that storage limit. The problem is now, storage limits all have to be destroyed by March 31st. So for the people that grew outdoors this year and have a 2-year supply on hand, on March 31st, that has to be destroyed.
Just a good
And we know that all the wonderful law-abiding citizens will do that, and then you'll be able to purchase the next day at 700 times the cost of it for you to grow it.
Why do they use plants instead of grams or ounces? Because the plant is so variable as to the production.
When you look at the numbers, what they've done is a scale. David Shea on his madstorage.ca website has the calculator, and you can input how many grams per day equates to how many plants you're allowed to have growing. And they base it on numbers of indoor. You can get, depending on how many plants, roughly 200 or 300 grams per plant.
So they just use a formula.
Right, outdoor, you can get pounds per plant. So you get a lot less plant numbers. Plus indoor, you can grow three times a year if you want to run quick grows. Outdoor, you're limited to one unless you can pull off 2 autoflowers in a season. Right? But the numbers are off.
Yeah, they can fudge them so easily.
They are completely. The other thing is about that number of plants, and they count each plant. Each plant is also $1,000 in their calculation. So every seedling you have popped, Pat has his 50 seedlings. When those police go in and they seize those 50 seedlings, they just seize $50,000 of cannabis, and that's how we'll hit peak media, because it's an easy number. If you're caught with dried cannabis, and it's weighed, then the price that's put to that is $10 a gram. That means your pounds are $4,500 pounds, not $1,500 that you can buy on the street, right? So the numbers are inflated that way. You got caught with $50,000 worth of cannabis, right? Just more things to cheer you up. I think I saw a hand way back there somewhere.
Yeah, so the thing,
Pardon me?
verbally, I got them calling them on the phone. If you have to just use a knife and you walk into it, it's outdoor. If you have to use burglary tools or other tools to get in, then it's indoor.
So you got the same answer that I got then.
Yeah. So they said even just dropping the chip wire is good enough. But if you recommend glass in the door to the gate, what they're picking up.
All right, then I'll put 146 plants out there.
Just for a hypothetical, it seems like this whole MMPR is set to fail. Like, we're talking about growing, but this is all going out in March. And if you don't have a license, why would anybody apply for a license to even consume cannabis? Because all you're doing, I mean, the conservatives got rid of the gun registry, but now it looks like they want to have a registry for everybody who consumes marijuana. So
Did you register your gun?
who's going to do that? I mean, I think in the eyes of the law, hypothetical, if I don't apply for a license and I get caught, and I never bought anything in my life, and I never sold anything in my life, and I don't have a criminal record, would I stand a better chance in a court of law if I don't have a license to consume?
I'm in the same boat with him. Mr.
Well,
Rogers.
your license to, it's not a matter of license to consume, because consuming cannabis is not illegal. Justin Trudeau said to the media that he'd smoked pot, and he can legally do that. He did not break the law by saying that he consumed it. The law states that it's illegal for you to possess it unless you're legally licensed to do so.
Well, I can't consume it unless I possess it.
Right.
So in a court of law, do I stand a better chance if I'm an unregistered consumer?
Your registration ends March 31st. You get a new registration now.
But they know from my license who I am and where I live. Now they can have a search warrant because I'm a suspect, right?
Right, which means that anything that you have has to be packaged with the label from the commercial producer that you purchased it and paid your taxes to.
So you're telling me it's better that well, hypothetically, I don't consume cannabis. I don't grow cannabis. I don't consume cannabis.
But
I'm here to get information.
But and it's not a matter of that. It's if they come into your house, if they have reasonable cause, whatever reason they want to come up with to come into your house, and they find cannabis, then it's going to be a matter of, do you have a valid MMAR that runs past March 31st? Mine does, all right? So the last letter I got, it's the only one that I really read, is that that license is good and I can use that to purchase from licensed commercial producers. But
Okay.
March 31st, I still
Yeah.
have to destroy anything I have,
Yeah.
and anything that I have after that has to have that label, or I am possessing illegally.
Right.
Do I have a better chance in court because I had the MMAR and not? It's a matter of first proving medicinal need, which obviously I did by having a registration before, and proving that I'm still using it as a medicine, and I have to get it on my own because I can't afford what the government charges.
Okay. Now, if somebody came into my house for a different reason, whatever that would be, I don't know, and they saw cannabis, they don't have a warrant to search my house, do they?
If the police agency is on your property legally, i.e. with a search warrant, it doesn't matter whether the search warrant is for guns and they find dope or vice versa. What matters is just black letter law. If in having a valid search warrant for item X, they find evidence or contraband that is illegal, that contraband is perfectly admissible as against the property owner.
Okay, but they would need cause to have a search warrant.
In order to get a search warrant, the police have to have reasonable and probable grounds that contraband or evidence of a crime will be found in the location sought to be searched. And what happens is the police officers swear out what's called an ITO, information to obtain, and they set out the grounds as to why they want to search a particular piece of property. And many paragraphs long, and they go to the Justice of the Peace Center here in Halifax, so actually located in Dartmouth, I should say. And Justice, after reading it, either grants or does not grant the warrant. The warrant has been granted. Within the time limit specified in the warrant, the police are free to search your property. I mean, to what extent information that was provided, presumably all of the licensed users and the licensed grows were licensed through Health Canada. They're on a database. So to what extent that database is shared with the police, my guess is legally it's not supposed to be. In practice, I'm sure it is. Just like one of the ways they will tell whether you're still growing, we look at your electricity consumption. Technically, they should get a warrant. The head security guy at Nova Scotia Power is always an ex-cop, and they just call out, buddy, tell me what the reading is on buddy's feet. They say they don't do that. I don't do that for a minute, but that's what goes on. One of the ways they will track people who had indoor legal or lawful indoor grows will be to look at your power consumption. That's the first clue.
I'd like to point it to, like, for me, for example, my meter's right up on my head. So the police don't even need to call the power company. They can just go look at the meter. You might have to use the vernacular to look at the numbers, but then they can just come back a month later, look at the meter, and anybody can do a calculation based on the meter.
Yeah, the meter isn't covered, it would be an illegal search. I mean, the other thing they do is they run called FLAR. Basically what it is heat sensing, TI or thermal imaging. And obviously indoor grows tend to generate, they tend to be warmer than the ambient temperature around here, more than you would say allow for a room of 20 degrees. And they just have a little drone and they fly over stuff and they get a FLAR reading, and that starts the basis of their investigation. They have a higher than normal thermal imaging for a particular property, and they'll say, aha, that's suspicious. And they go look at your electricity consumption. You keep on going down the line like that.
You should also be aware that for the past year and a half, the Canadian Real Estate Association and the RCMP have partnered in a program that if your house is up for sale, or you're thinking of putting your house up for sale, and you're having a real estate agent come through your house, and they notice that you are more than likely, potentially, even having a small personal grow up in your house, they will inform the RCMP, and you will get your door kicked in. There are many real estate agents who do not like this at all, because it places them in a position of risk going into some people's homes who may be growing for commercial purposes. And they're not trained to do this, and they have complained to the Canadian Real Estate Association that they don't want to participate. However, as an organization, the Canadian Real Estate Association has partnered up with the RCMP to inform on people who are selling their homes.
This is scary. It's like we're becoming a police state.
Like we are becoming?
You already are.
We already
You can't hurt
are.
it.
Got a cell phone?
No.
Turned off.
Couldn't afford to pay the bills, so I let it go.
Is it
I'll
turned
say,
off?
"Rick,
Gentleman
you're off
down
anyways."
here.
So you think?
Sir?
I grow for myself. My license runs out February 16th. Now, I put in for a new license back December 3rd. I still never heard nothing about it. Now, I got my marijuana coming off here next month. What's that do there? Did they charge me this one before the end of the month? You better, because that way you got it. So they say.
They've stopped renewing licenses in October for production. So you wouldn't get a production license renewed after October when you apply.
Production licenses can be renewed, but not renewed, like lapse.
You could have your possession license renewed, but his renewal would be from February 16th until March 31st.
What
Right.
happens after March 31st?
No, that's a new application since October. I'm positive of this. Since October, they don't accept new applications, but if you're already growing,
Right, you can't, he had to renew his license is the problem. So he can't get a renewal for his grow
so
license.
am I classified as illegal?
You're what?
Am I classified as illegal?
After the
Not
16th.
yet. Well, do you have a valid license now?
Right now, it's over 16.
Yeah.
You're legal till the 16th.
That's what I'm saying.
But don't throw out that old license, because you'll need that if you have to go to court.
So he can still get a possession card, right?
Pardon?
Possession card, right?
Yeah, you may still get one. You may still get your renewal for possession, or to be able to
Possession card
possess
don't
your.
probably grow, right? That's just gives you the right to have marijuana.
That's right.
Right. The problem is the possession license is different than the grow license, because the grow license has the storage limit.
Exactly.
The possession limit only has a 30-day supply limit on it.
Oh, that's, okay.
So,
Terry? Yes?
I just renewed mine in mid-December. I can grow until the end of March. I have to destroy anything I have. I do not need to buy from the new sites until the end of December. I can still go through airports with my license until the end of December, but I do have to destroy my supply. But I renewed, they will not take any adjustments to the renewal or new applications, but it's straight renewal using Form R, they will do it.
The letter that they sent out in November contradicts that when it says that all storage has to be destroyed by March 31st.
Right.
So that's
That's on
again,
paper.
just another conflict in the crap that they're trying to pull.
I did see online in the last couple of days as well, someone that got recent correspondence from Health Canada indicating that they wanted us to notify them as to having destroyed our medicines from the end of March and how much we've destroyed. So don't be surprised for a minute if that's the next round of mail we get from Health Canada.
I'll send them weekly video updates until September or August.
Somebody over here has a question.
Question, yes, ma'am?
If I have a license to grow and possess, and my possession or my grow license as of March 31st, if I don't purchase from the government, do I lose my possession license? Are they going to say that I no longer have a possession license?
Yeah.
Yes, basically. That's what it's going to be treated as.
But if they, well, if I don't buy a first or within a certain period of time, does that mean that my license is no longer valid?
The whole MMAR program itself, which all of our licenses are, becomes invalid and defunct on March 31st.
But our possession licenses don't do that.
They don't, which just means that you can still use that to purchase from the new LCPs.
But if you don't do that,
You just can't possess your own.
I filled in for my license and mine went out in December, and mine was sent back because I've reached my 5th year. So after the 5th year, I have to start all over again with pictures, the whole works, application, renewal. And what happened was, is that ended my chances of renewing this year, because my next choice would have been by Health Canada. They sent me a list of growers that I had to start from now, right? So the license is gone, right?
It's exactly how it is.
Yeah.
So, yes, your license, you'll
You just
still
gotta
have a
go
paper.
be illegal, right? That's all. You gotta go in the back underground and fight for it. Like I said, you have the right to defend your property, opportunity to use that if you feel threatened by the police. But if you're not able to protect yourself, that's the problem, right? You have that right anyway.
Chris? Yeah, Chris is first.
Just, okay. It's for,
Hang on one second, everybody. Hello? What? One at a time.
just about what we
Wait,
were
Chris
speaking.
right now?
Just about what we were speaking about. After the 31st, if you have a personal possession license, it doesn't matter is the point. Because the only marijuana that you're supposed to have is the stuff that you bought, and your license is the prescription itself. So it doesn't matter if you have a license till 2018. It doesn't matter, because the only marijuana you can have has to be bought from one of the dispensaries, and that receipt is your license. So the license you have after the 31st does not matter.
Question? Yes?
I have another question.
Yes, ma'am.
He was talking earlier about if you get caught with it in trafficking and with, you could lose your house and everything. What happens if you jointly own property with somebody that you're no longer married to and they grow? Do I lose my house because somebody else is growing in that home?
Well, it depends to what extent your interest in, each individual party has an interest in the property. To what extent the co-owner was complicit in the illegal activity. Theoretically, they could order a severance, and you'd have to turn over half the value, that kind of thing.
Short answer is yes.
Yeah.
What happens if you worked your whole life?
Pardon me?
What happens if you worked your whole life and made an income?
Yeah, if you own a piece of property, it's used to produce, a scheduled substance. It is offense-related property, and it's subject to forfeiture. That's the law.
Okay.
That's why commercial guys rent. It's that simple. That's why when they go on drug runs up bringing tobacco, they rent the vehicles, they don't lose the vehicles.
question. I have a home and it's been paid for like 2 years ago, right?
Yeah,
And I worked all my life.
yeah,
I just got my medical marijuana in September.
yeah.
So if I'm caught, they're gonna come in and take my home from me?
No.
Even though it's.
For simple possession, no. The question is production.
For the purpose of traffic.
No,
For the
if I
purpose of
grow,
traffic.
I still grow in my home, say, if I wanted to, right?
Theoretically,
And I get caught,
yes.
and my house was paid for 2 years ago. And I worked all my life, and I showed that my house was paid
Yeah.
for. How can they say, take my house and say I paid for it, the gross?
If you're convicted of, depending on exactly what you're convicted
But
of,
that's only if it's production.
for the purpose of traffic, yes.
Production
does
for
that-
self, they wouldn't.
Because I'm just
Probably
wondering right
not.
now, all
But I'm
these
just saying-
people that are growing, right?
Right, but you're growing it for yourself.
Yes,
So,
for
so,
myself, right?
what the law is they can take that property if you're producing for the purpose of trafficking.
But no, I'm just saying.
Because you're using it for yourself and you can prove that you're using it for yourself,
Okay.
it's very unlikely they would even bother to try to attempt that. Because the media and the public outcry alone could be detrimental to them, so.
Hey, another question. Everyone here is growing right now, right? From our last grow till March 31st.
Not me, nothing grows outdoors right now.
Or whatever.
Yeah.
You know, what happens, why are we allowed to grow it then from March 31st, but it's everybody grows?
Because that's when the program ends. So we can only have it until the end of the program.
All right.
All right, so you can only have your garden until the end of the program. You're supposed to, basically, if you have a grow room on March 31st, you better dismantle all of your lights and everything else to be compliant within the law.
After that date, the next time you take your gear, put nothing there. When you start looking for a base or something.
After that date, if you have your gear set up,
But there's no plans there, right? Just set up.
That's not illegal.
and that's not illegal, it's not illegal to have the equipment, because you could say that you're gonna turn around and start growing tomatoes.
That's just.
All right.
Guaranteed, never seen a cave. There's not-
Don't forget, you can grow your lettuce and your tomatoes in your grow room and have fresh veggies anytime you want.
Exactly.
Question here?
Yeah, I was wondering, this all work in stone now, March 31st?
It is, March 18th, John Conroy will be in court, right, through the lawsuit that they launched. He hopes to have an answer on the injunction before March 31st.
If he gets the injunction, then the license will continue?
Everything will stay status quo as it is now. People will have to reapply to the MMAR. The idea is really the injunction is to be put in place until the legalities of the MMPR are fought out in court. That could take 5 or 6 years, right? So this is why that injunction is so important right now.
So there is still hope.
There is still hope. But we were on air the other night on the 420 radio show with John Turmel, and he's now helping us. And for those who don't know, John Turmel is becoming pretty much a self-litigator, and he's helped quite a few people in their cases. So what he's doing is we're coming up with a bit of an action plan, and basically everybody files suit the same day. So instead of one big suit representing hundreds of thousands of dollars for the lawyers, everybody files their own suit to apply for an extension to their license.
So
Flood the courts. Basically, the last week of March, we'll have everybody go take their statement of claim, their money into the court, have it certified and entered in, and flood the courts with all of basically 40,000 patients applying for their own extensions to the MMAR. And it might actually drive enough thought home how stupid this MMPR actually is, because that could tie them up in court for a long time.
where you sign up for that?
We're going to start making this stuff available. I think MUMM's going to be putting it up on their website. The MCPAC, We'll definitely have it. We'll try and get the word out as much as possible. And it'll also be going in, pretty sure it'll be going in the next MUMM newsletter as well. It's just a matter of simplifying it out so that everybody can file their own statement of claim off of a format. Yes?
Yes. I've inquired to Health Canada, not only Health Canada, but to my medical insurance and to workers' compensation. If to ask them if my medical insurance or workers' compensation would pay for this medical marijuana, and neither one of them will pay for this medical marijuana. So when this becomes law on April 1st, is that going to change to the degree that I will be able to claim this on my drug plan, or will workers' compensation now pay for a drug that they refused to pay for before, but is crucial to my health care?
You're still not going to get it covered because there's no DIN number applied to the drug.
There's no what?
DIN number, it's a drug identification.
Why is that?
Because Health Canada doesn't recognize it as a medicine, but the other issue is the plant has no consistency, so you can't give a DIN number to a plant that two clones from the same plant, one produces 18% THC and the other one produces 15% THC. It just happens, right? So there's no consistency even between the same plant, let alone the literally thousands of strains. Veterans Affairs have been starting to pay for some of their patients, or pay for their medicinal cannabis. They have to buy it from Health Canada. And how they've gotten around it is by applying the DIN number to the patient, right? So the patient themselves has their own DIN number, so that then gets billed back on that DIN number. If your insurance company wants to give you a DIN number to help you pay for it, then they would do that. They're not going to. It's not in their benefit to do that. But it was the only option that the military had for these certain individuals that have been successful to get that.
Blue Cross is the underwriters for workman's compensation and the veterans. So,
If you can get workman's comp to...
which is Blue Cross,
No.
yes.
If workman's comp applies the DIN number to you,
Well, Blue Cross has,
Blue Cross pays
yes.
on the DIN number. All right? So the DIN number has to come from the governing body, which would be workman's comp. And then workman's comp submits the bill or submits the payment based on the DIN number.
Well, Blue Cross pays for my prescriptions.
Yes.
Under workman's compensation, they call it workman's, but it's Blue Cross.
Yes.
Now, Blue Cross also underwrites veterans.
Yes,
Same
but you
Blue
can't
Cross.
but you won't get cannabis from your pharmacy where you use your Blue Cross card.
Well, I'm going to look into that, because if the vets and the underwriters of Blue Cross can get a DIN number, and it's still Blue Cross.
But they don't get it from their pharmacist either.
It's Veteran Affairs that pays for it, not
The DIN number is
No, see, Blue Cross is the underwriter,
Yes.
medical
We have a
underwriter.
pharmacist in the mix who can answer that
Yes,
question.
Oh,
a DIN
okay.
number is for the
Okay,
billing.
here's your conundrum. Just because you have Great West Life does not mean that Great West Life pays those bills when you walk into the pharmacy. Assure pays those bills. When I bill your medication, yes, I bill it to the Blue Cross payment plan, but it's Veterans Affairs who has authorized that through Blue Cross. It would be Workers' Comp who has to authorize it through Blue Cross. So it's the people at the beginning that you actually are dealing with, your Workers' Comp, that has to say, yes, that's going to be covered, and then they give the authorizations for Blue Cross to actually pay your prescription when you walk into the pharmacy. So yes, Blue Cross pays for Veterans Affairs, but that's because they're up here and that's who the pharmacies deal with. You're down here with who I cannot call normally through to Veterans Affairs directly and get them to cover. Okay, I have to bill through Blue Cross, and they've been given the okay from the bottom. Same with Red West Life, Mutual Life. It's all paid for by Assure, that's the big company. But these other little companies have gone to this big provider because they have the expertise. So until your workers' comp says, yes, I'm going to give that DIN number to you, just like yes, Veterans Affairs gave it to this person, Blue Cross is not actually paying for it. Okay? So they're the big provider that the pharmacies talk to, not the little guys who you actually have your coverage to.
And this
Can I say something on workers' comp? Because I'm going through Ontario. I don't know how Nova Scotia works. But they do give it. They do give it, okay? They do give it. If you look, there's actually it was last, in 2011, the last case was awarded from a gentleman out in BC that got it. And how workers' comp does it, it's based on the Health Canada pay chart. Only up to 5 grams is what they do, okay? So in the province here in Nova Scotia, based on 5 grams, I think it's $1,050. That's what you'll be reimbursed. But what you have to do is you have to get it into the system by submitting in a receipt for it. Let them say, no, we don't accept it. Then you have to appeal it. Now you have to get somebody to take it in front of the class action. Or not class action, but the appeals board. Once it gets to the appeals board, that's where the stamp's put on. Okay? Mine's been waiting to go in front of the appeals board since 2007. We're hoping to get it moved this year.
So don't expect a backlash reaction when you apply, folks, I guess is the bottom line.
Well, you have to go through the whole procedure. It has to be, and it's exhausted through the whole system, and then you have to go through it all. So if you're going to get it, you send in, let them refuse it, put it in, submit a receipt, and then after that, then you're on
I've
your way.
already been told now, so it's complimentary, he's not even working with the appeals board on.
They all won't, but they have to.
Is
Okay?
it because there isn't enough studies done, they won't catch it?
That's what they all say.
Are you using it for pain?
Yes.
There is a community,
Now,
there's a
your
community
doctor's
study that's
obviously
ignored
prescribed
that you could
this way
use.
that they look at it. Your doctor signed you off to this, to use cannabis as medication, right?
Yes, but workman's comp says.
That doesn't matter, that's
studies
all,
that
that's
don't
their
have-
policy. The girl has to read off the script, you adjudicate, it says, no, bang, so it has to go to the next level. And you have to get it there. They're not gonna tell you what avenue to take it, but the avenue to take it is to get the, submit the receipt, so that you get a letter saying that, no, we don't pay for this, then you appeal it. Once you appeal it, then you've gotta get somebody to take it to the appeals for you, okay? They have to look at it there, and then it's honored through that one, because it's recognized as a medication from your doctor for you, then they have to pay for it. But it's just getting through the system to get to it. It's tough, but they do it. You can look up online, there's probably about 6 or 7.
Shoot, Debbie.
So does does workers' compensation pay for anybody's marijuana?
Yeah, there is. There's right online.
They told me that they don't.
They tell you a lot of things. They tell you that they don't cover it, but once you take it to the appeals board.
Craig, isn't this in Ontario?
And I'm
Yeah, but
just
they all
wondering-
run under the same policy. They all
I'm
run under the
just,
same policy.
excuse me, I'm just wondering if the workers' compensation talk would wait until the break because it's not really pertinent for the gentleman sitting up front. I know it's important for many people sitting in the room and perhaps at break, if people wanted to congregate somewhere, that discussion could happen. I have a question for Mr. Atherton, wondering, with what Marcel was talking about, the potential of patients going into court en masse and launching an individual injunctions against the federal government. How do you perceive from your perspective that being met with in the courts?
Actually, probably better off asking Dan that. I practice almost exclusively in the criminal law area. And you don't do mass violence in criminal law, you defend one person at a time. point one, you know, my own, in order to get an injunction to stay something, you would have to allege, at least to my knowledge, and again, it's based on criminal law, a breach of your charter rights. You have to have an evidentiary basis for that. An interlocutory injunction, by piling in there 2 days before a law is to take effect, practically speaking, I don't see it happening. Not without an awful lot of careful preparation. And if you were seeking an interlocutory injunction, which is what it would be, as opposed to a final injunction, you should have filed it, I would have guessed, with some considerable evidentiary record almost as soon as this thing was filed, if you have to hope to have any chance of success. Now, there might be another civil basis for doing that. I'm not sure exactly what basis Marcel's guy was talking about, but I'll turn it over to Dan, who knows a lot more about civil law than I do.
Sure. I think it's fair to say that the judge will recognize what's happening, and they might not look too kindly on piling on the last moment, 48 hours or a week before the law's about to change. There was notice about this at least for a couple of months now. The judge would fairly ask, well, why am I just getting this now? And it appears that, you know, you're trying to flood the court.
We're not filing for an injunction.
Oh, you're not filing for an injunction?
No, the injunction's being filed on the, there's being heard, it's already been filed.
Right.
It's being heard on the 18th. In BC.
Are they looking for a suspension candidate?
Yes. Yeah. What we're doing is, all we're having people do is file for an extension to their existing MMAR to allow them to keep their stock, the quantity that they have without having to fall under that destruction notice. We don't have to file an injunction, that's already being done.
Right.
If that one fails, we have another way that's ready to file another injunction as well. So
I don't see the benefit of waiting to the last minute to file for an extension, but
it's our problem is just getting this all out so that people can just do this themselves.
okay.
That's what that's taking us time, is making sure that lawyers have looked at all of this and that it looks legitimate for each patient to be able to use this in a way.
So you'll have a template, and then basically people fill in their own
Yes.
personal information.
Download the form, fill it in, print it out, take your money. In front of the judge and say, that's why I need my extension.
David? If I could, I'd like to add 2 points to Marcel. And it's actually Jonathan Mills. He's got 2 kids. One is meant to be filed, a month before everything ends. And it's on the basis of saying that if I've got to destroy all of my marijuana, well, that marijuana has value. So I want to be compensated for that. And the second part, it's to strike down the MMAR and the MMPR. So it's not really to extend our licenses as much as to say the whole system is constitutionally flawed. And they're using what Murdoch said, that there wasn't enough signing doctors. But they're saying, instead of saying, okay, so there is signing doctors out there, so there's enough. But the problem isn't that. It's that doctors are refusing the refusing. So that's the point of the thing, trying to knock down the MMPR and the MMAR.
But now we have that in court already with that decision coming on April 24th with the R versus Godfrey.
Yes. And
because that's where we proved that the reasons why doctors weren't signing.
Yeah.
So with that then, but then the MMPR comes into effect on April 1st.
Yeah, I don't think John Terrell's purpose is to extend our licenses. Because like I said, his purpose is to strike down the law completely.
That's what his purpose is, but that's what the decision is that we're waiting for from April 24th.
Yeah.
Because when the judge comes back from that verdict, when he comes back and says, yes, the MMAR is unconstitutional, therefore the cannabis laws are of no force and effect again, and then it'll go to the Court of Appeals, and we'll do it again. At least this time, when it goes to the Court of Appeals, we've got that reasoning of why the MUMM failed. MUMM proved that doctors weren't signing. But when it went to appeals, the question was raised, why weren't they signing? Maybe they had legitimate medical reasons why they weren't signing. So that's why it failed in the Court of Appeals. Now with R versus Godfrey, we've gone in and said the doctors aren't signing, and this is why they're not signing. Right? So on April 24th, everything may be moved again, the same as it was after the first verdict for Murdoch. Regardless, they'll still push minimum mandatory, so if you get caught.
So with the whole middle man, and it's right now illegal to grow, I have a small children in my house, and I live close to a school. Pretty soon that's coming to an end. I also live up to my house is store. They come down through my door, which I know there, but I piss them all off. What do I do with my free throws? What do I do? I will defend my property. What do I do with the kids?
It's a matter of personal choice. Maybe ask Pat for a card. Get a business. No, maybe get a business card from Pat.
You know, I need one before you leave, because I know they're coming to my house. I'm just saying, I know that. I know they tried already.
This is a quandary that most of us are going to end up experiencing, because we're all going to end up in some kind of legal quagmire here after April 1st. What we don't have at the moment is a large supply of from the legal profession who understand what the changes are going to do to everybody and how to defend that. And a question I have is, how do we educate the legal profession in this province to put together a legitimate defense of what is about to happen in the next 2.5 months? Where do we find these people? We have, as an organization, been looking for legal opinions for quite some time. There are just not that many people that are qualified to speak on this subject. And now it looks as if there's going to be an awful lot of court cases that are coming up, depending, I guess, on how the Provincial Ministry of Justice decides to allocate their police resources.
That is the drug enforcement, well, drug enforcement, drug prosecution, two different things. Drug prosecution is handled directly by the Federal Department of Justice for historical reasons. Drug enforcement is split between the HRP and the RCMP, and they have a combined unit. But the policy, for example, if you are, very often one is charged with production, one is also charged with possession for the purpose of trafficking. Or if the mandatory minimum was to apply under, very most likely you're only going to get convicted of one. The direction from Ottawa is that if a mandatory minimum applies, you will not deal that away. So in other words, if you could catch somebody on a 5.2 for weed, none of the aggravating factors apply, and therefore be eligible for CSO, yet you were subject to a mandatory minimum because you were growing it at 7.1, the drug prosecutors are instructed by Ottawa not to deal away 7.1. You know, they're playing hardball.
Right. So that's legal.
Yes.
And the judges can't defend themselves against that. Where's the justice there?
Well,
We don't have any.
The Quebec Bar Society is fighting it now.
Well, even in the states, they've been refusing to hear the
don't
cases.
just apply in these cases. It's like the stupid victim find surcharge. It sounds great on the radio. Most of the people that we represent and go through the system haven't got a pot to piss in. And they all have to pay, what is it, $100 or 15% for every chicken shit little charge that's out there. These people aren't ever going to pay it. What do? Create a colossal amount of paperwork we're never going to collect. But it sounds great on the radio.
Peter McKay says they can have a yard sale and sell the things.
I have a question. Are you winning any cases?
Oh, yeah.
Related to what we're discussing here?
Have you had any cases with medical cannabis patients?
That have been prosecuted? No. Most people, the ones I have had have to do with people who have either obtained the licenses fraudulently and then used the grow provisions to grow marijuana far in excess of what was allowed for in the license, and then that marijuana is they turn around and sell it on the black market. I've had lots of those cases.
Okay.
I mean, I was curious what one does not, because all I get and my colleagues get are people who are actually charged. I have no sense of how common it is for people to grow their own marijuana. So I don't, I was interested in earlier, you were saying 5 to 6% abuse of the system.
Actually, it's a less than 0.3% conviction rate.
Yeah.
Of
the issue from my point of view is I don't know. There's no database out there that says there's 1,000 licensed home grows here, and then we would know how many illegal ones there were on top of that. You don't know. It's like you'd have no idea when you look at a search warrant cases how many searches came up dry. Right?
They don't keep-
Because they don't keep a database, or if they do, we don't have access to it.
I think come March, it's going to be a hit and fight, right? And there's only going to be so many of us they're going to arrest, which is probably going to be me. Right? What I expect of, seriously, what I expect of is that when we do go to jail, that the rest fight to get us out.
Yes.
Because I'm going to be the first one to go. I'll bring my 10 plants up fully blossomed and turn myself in Halifax, right?
Go, David, go.
So, whatever, but I mean, it's going to be a fight, no matter what.
And a quick question to that, like, what would you perceive of patients who might be willing to turn themselves in? We have a member whose license expired last month, I believe.
no, just this week.
Just this week.
Yeah, third.
Could be charged with possession at this point, and in fact would like to be charged
He
with
wants to
possession
be charged.
to be able to proceed through the courts with this.
Well, for simple possession of marijuana, the penalty is a fine. That's all it is. It's very rare that anybody gets jail
Break
time.
here, because we can't sit any longer.
Well, that's after a while you start getting some time. Generally speaking, it would be unusual for a person not to get a fine for simple possession of marijuana. Where you get yourself into trouble is production for the purpose of trafficking and or trafficking. Those are the two. Typically, marijuana has been seen as a soft drug, and in the grand scheme of things, it's a low ender compared to, say, cocaine, where which is the kind of stuff that I do more of.
Can somebody just launch a charter challenge without having to be charged? Go in and say, hey, I got these plants I'm supposed to destroy them. I want to launch a charter challenge?
Yeah, I always do them in the context of somebody being charged if they're specific. A general charter, you have to have what's called standing. There's a whole law around that. You have to see an expert on that. I'm not going to sit here and tell you I'm a constitutional law expert. I know lots of.
Well, I do have a question that you might be able to answer. If my wife is around me and I smoke pot, and she jumps into the car and she drives down the road, and the police officer pulls her over for sort of as a check stop. She rolls down her window and he doesn't smell the pot off her. Why is that a probable cause to search her vehicle?
Well, it wouldn't be. There's some case law around that, because when you smell the pot, it's already burned. When you have grounds to search a car, that's why there's a couple of cases that came out of Nova Scotia about 8 years ago, where the police did exactly that. They alleged that they had smelled pot.
I know someone, I'm not going to say who it is, but I
And let me answer the question, or are you going to
Oh,
ask me another one?
I just wanted to say that I know someone in this room that was pulled over and had stuff taken from them based on the fact that they could smell pot.
Yes, I hope no doubt.
So, yeah, okay, thanks.
Could you finish that?
Sure. Anyway, what it comes down to is, in order to search something, the police have to, there has to be search incident to arrest, or you have to have reasonable probable grounds for a warrant. The argument was that it was a search incident to arrest when they searched the vehicle. And the way it went out was, well, the smell of the pot meant that it had already been consumed, so you had no reasonable grounds to believe there was still pot in the vehicle, so therefore the search was chucked out. So now the police get there and they tell us they smell unburnt marijuana. So you see, I mean, it's been around the block in the criminal bar a number of times.
So it's still great.
Oh yeah, for a criminal offense, you're defending one person on one specific set of charges. And you work within the fact parameter that provides, which, and as a general proposition, it is unwise to try and expand the conclusions that you drew from that particular case to a general set of propositions.
So if you're caught on a possession charge and you have a quantity of your medication, why is it not just simple possession as soon as they find digital scales in your house? Now, as a pharmacist, I can tell you that if you have a prescription for $240 divided per month, you will abstain, you will to be held to that. Why is it that every time that anybody that has any amount of possession and has a digital scale in their house is automatically thought of and charged with possession for the purpose of trafficking? Why? Are you not expected, and would the lawyers and the prosecution not expect that that person who has a medical license for 30 grams a month is not going to measure that? I sat in court and listened to that the other week. This is ridiculous. How is that person going to measure their medication? According to the RCMP expert witness, you're going to eyeball it. How do you get past that?
When a person is charged with possession for the purpose of
Can you
trafficking,
speak into the microphone, please? Thank you.
when a person is charged with possession for the purpose of trafficking, the police must show that it was for that purpose. A scale is only but one of the indicia that the person possessed it for trafficking. In the case that you were before, I would be somewhat surprised if that was the only indication of trafficking. Typically, there is, like I said, packaging, an excessive quantity of cash, sometimes a lack of materials to consume it. They would very often have score sheets, which is basically a record of drugs that were fronted to people. And you would typically see score sheets in a weed transaction as opposed to a coke transaction, because coke's way more expensive and they're a lot more unreliable. Very often they have text messages or emails to support the indicia of trafficking. So I would have been surprised that on a 30-gram amount with simply a set of scales, that was all they had. I would find that somewhat surprising, to be very frank about it. The other reality about it is they don't just happen on these things by circumstance, although they're never proven in court. The way these searches and warrants are granted, it's kind of the dirty little secret of Canadian law, is that there are sources, and in street lingo they're called rats. And they are guaranteed confidentiality. It's the second highest form of privilege in Canadian law. The only higher form is solicitor-client. And basically, the way it works is this: the police cultivate people in the community for money, among other things, or they go easy on them on other kinds of charges, and they say, "Where did you buy that crack? Where'd you get the stone? Or who did this or who did that?" That person becomes source A. And they'll say, "I went and bought it from John Doe around the corner." And they write it in a little notebook, and they keep a database. And they hit another couple of people, and they squeeze the junkies. And the junkies are unreliable. They don't want to go to jail. And you get three sources, A, B, and C, and then one of them says, "I just bought it half an hour ago." And they say, "I was in there, and I seen the stash." And that's how they get the search warrants. None of which, and those people never have to testify. You never see them. You have no idea of knowing whether, in fact, they were not made up. In fact, I've seen so many search warrant ITOs, I can write it myself. Because because they all say basically the same thing. And you were never ever going to check it. That's how it's done. But typically, and that's one thing I do not know. I do not know whether the database that contains all of your names and addresses as registered medical marijuana users and or growers is readily accessible to the RCMP. I'm going to guess they would say no. I don't believe that, nor should you. That being said, there are lots of worse guys out there than you people. And they are generally rather more interested in hard drugs than soft drugs. But if you do traffic, you will eventually get caught because the people you were selling to are unreliable and they will rat you out. That's how it works.
I just wanted to say this is pretty well done, so we gotta switch the camera.
I like to have a cigarette.
Yeah, we need a bit of a break here, guys.